All right, could I have someone for the state? It's Criminal Trial Division. Court is calling 2024 CR 4983, State of Texas versus Jessica Marie Bonner. Can I have parties announced for the record for the state? Defense?
Sean Sheffield.
Are you Miss Bonner?
Yes, ma'am.
Counsel, have you received all of the discovery? Did you review it with your client?
I did hear.
Ms. Bonner, did you sign the document entitled Application for Deferred Adjudication or Community Supervision did you sign that?
Yes, ma'am.
And did you review it with your client? Did you review the document entitled True Bill of Indictment with your attorney?
Yes.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right. Did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it?
Yes.
Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of fraudulent use of possession of identifying information, less than 5 items, elderly person? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you're giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, yeah.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Bonner, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there's a $2,500 fine. State is recommending deferred adjudication. There's to be restitution to Caroline Caldwell. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you agree? All right, so everyone, we're on the record. No talking behind the court reporter. If you need your person moved to the other end, they can be moved to the other end. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
This is a serious moment of third-degree felony with 2 to 10 years in prison and up to a $10,000 fine. Imagine how nerve-wracking this is for the defendant. Notice how the court is meticulously ensuring Jessica understands her rights before accepting any plea. This is classic courtroom procedure. Every word, every signature matters.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Clear.
Outside the agreement, state is requesting that your deferred adjudication be for a term of 8 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with Caroline Mullins Caldwell. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contact.
State, any evidence?
Contained in Exhibit 1 and attachments, Your Honor.
No objection.
All right, you may be excused.
Thank you, Your Honor.
Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes,
Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
Your Honor, we just asked the court to follow this recommendation.
All right, what's the name of the complainant's son who allowed you in the home?
It's David Swagwell.
What's your relationship to him? All right, do you have any children?
Yes, I do.
What are their ages?
18 years old, 17 years old, 16 and 15-year-old.
And who are they with?
They're with their dad right now.
What's your drug of choice?
I was on meth, but I've been clean.
All right, were you clean when you committed this offense?
No.
All right, so why are you taking things that don't belong to you?
I was in the wrong place. I needed money at the time with my kids, and it was just opportunity, and it was wrong for me to do it.
Who is Melissa Campos?
That I have no idea.
And is Child Protective Services involved in your case?
I don't think so. I'm not sure.
When's the last time you had employment?
Well, I was working as a cleaning houses, and then I lost that.
Mm-hmm. All right.
Race where it gets interesting, the court confirms she's knowingly waiving her right to a jury trial. That's a strategic move, opting for deferred adjudication rather than rolling the dice with a jury. For viewers at home, think about it. Would you risk a trial or take a negotiated deal? Comment your thoughts.
Anything else?
No.
This is what the court is going to do. Court is going to sentence you to a $2,500 fine. That will be probated.
Thank you.
8 years deferred adjudication. There's to be no contact with the following persons: Caroline Caldwell, David Caldwell, Melissa Campos. There's to be no unsupervised contact with minors. There's to be a referral to felony drug court. That'll be first. A TAP evaluation in custody. And then last, if none of those places accept her, then we can do a referral to Esperanza Court and follow TAP recommendations if she's not accepted in one of those treatment programs. There's to be the UA hotline, regular reporting by Zoom or in person, field visits one time per month for 4 months, then at probation's discretion, proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors or in housing. You can't be cleaning houses or any place where you're around money or checks. You understand? 200 hours of community service restitution. I'm going to order parenting classes. Once you complete parenting classes, the community service hours will be deemed satisfied. And there's to be restitution, if any, to Caroline Caldwell. Probation, is there anything else she needs? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know. If you feel as your probation officer is not addressing that, you can come to court. We're here, but not on weekends or holidays. If you feel like you're going to use, pick up the phone, call your probation officer. And again, if they can't get you any help, come back to court. You understand?
Yes, ma'am.
All right, thank you. All right, court is calling 2024 CR 1544, State of Texas versus Francel Braggs. Could I have parties announced for the record for the state?
And prepare to settlements.
Defense?
Michael Dwight going to the defendant, Your Honor.
And are you Mr. Braggs?
Yes, sir.
All right, so the court ordered a TAP evaluation. It appears to the court that the defendant has a drug problem. And it's for possession less than a gram case. And I understand the reason for the state's opposition. And I'm sure it's because of the prior offense. Because otherwise, this is just a possession less than a gram case. So state, I know you're opposed to the application. Is that correct?
Correct, Your Honor.
So, Mr. Braggs, is he currently on parole for the repeat offense?
No, Your Honor.
Has he satisfied that sentence?
I don't believe so, Your Honor. Yes, ma'am. I have
All right, what was he sentenced? What were you sentenced to? How many years?
25 years.
25 years? Yeah, he satisfied the offense. I mean, he satisfied that then.
I did 25, I did 22 and a half years inside, then I got out and finished parole, and I've been out from my prior case for 14 years.
Okay. All right, so sometimes I can give people choices, sometimes I cannot. I know that when people look at defendants, they look at their history, right? To make a decision on whether or not somebody should be given probation. I understand that sometimes that's what people are going on. It's not the new case.
Whoa, she admits to taking things out of financial desperation. Real human stakes here beyond just legal terminology. Look at how the judge and attorneys probe into her history, employment, and family. This is where the audience connects emotionally, seeing the person behind the charges.
So looking at what you were sentenced for and how many years you received and the fact that you're no longer on parole, then yes, I'm considering that. And I'm going to put conditions in place to address that. But this is a possession less than a gram case, ultimately,
That is
that
correct.
has been enhanced to a third-degree felony. So I'm going to give you a choice. Here are your choices. Some people say being on probation out of this court is very hard. So I can sentence you to 3 years in the prison, or either I can place you on probation. And you're going to be found guilty, and you'll be placed on probation, or I can sentence you to 3. Which do you prefer?
Probation.
All right. So this is what the court is going to do. The court will find you guilty. Court is going to sentence you to 6 years in the prison, suspended. Any suggestions on how long he should be on probation, state?
6 years, Your Honor.
All right, defense?
Request for you.
All right. Let me think about that and I'll come back.
Yes, sir.
So there's going to be regular reporting, and you're going to have to report in person because the nature of your prior charge, I don't think they'll allow you to report by Zoom. Probation, if you all allow them to report by Zoom, that's fine. But if not, you don't have to. There's to be proof of employment. When's the last time you had employment?
November 2023.
All right, so there's going to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's going to be random, regular UAs, field visits. Somebody has children up here?
Here is a key pivot. The court weighs past offenses heavily when deciding between probation and prison. This shows how criminal history can dramatically affect sentencing even for minor possession cases. Legal takeaway: judges often look at patterns, not just isolated incidents. Makes you wonder, how much should the past influence the present?
That sounds in the hallway, Judge.
And see, that's a young baby, and this courthouse is so germy. People just don't realize, and children don't even have their immune system built up yet. So it's going to be field visits 1 time per month for 6 months, and then at probation's discretion. 120 sober meetings and 120 days. And we're going to do supportive outpatient treatment. And the state is taking in consideration night mag numbers 759930. And the court is going to place you on probation for 5 years. If you complete everything successfully, then he can always come back to the court and ask to be terminated early.
Thank you, Your Honor.
Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
We just want to thank the courtroom very, allow me to stand on my foundation and go back and do what I need to do for me and my family.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
And you understand that based upon the nature of your order of charge, you still have to make sure you stay in contact with them as well.
Yes, ma'am.
All right, we can go off the record. In this court, to be successful, communication with probation is key. Do you understand?
Yes, ma'am.
If there's an issue and you need help with something, ask probation. If you feel as though they're not addressing it, you can always come back to court. We're here every day except weekends. All right, good luck to you.
Thank you very much. All
right, you're welcome. Yes.
Does he need a thumbprint on?
Oh, they'll take care of it. The deputies will. All right, Carly Green.
We filed a motion to modify bond. I'll give a copy to the state and hopefully, but we'll,
I mean, do you want to hear that right now?
it's, possibly,
You know what, it's saying May 25th. It's already passed.
May 25th.
Yeah.
But, oh, he filed it last night. It may not even be the file.
Oh, okay.
Yeah, it's all right.
All right, so you're in jury trial?
Yes, ma'am. Maybe
All right, so everyone, please whisper. When do you think the trial will conclude?
Thursday afternoon.
All right, so when do you want this called back? Because I know sometimes you have to have some downtime from a trial.
Well, I'll say this, I'm out of town the first 2 weeks of July. Going to Canada, hooray. So sometime either between then or after that, if that makes sense.
All right, so you want July 15th?
We get back on the 16th. I would say the 17th or later would be ideal.
All right, you want to do it the 18th?
That works.
All right. All right, and so when you come back on the 18th, we're going to give you your jury trial date for this.
Sounds good, Judge.
All right, once you sign the reset form, you're excused.
Thank you, Your Honor.
All right, and I talked to you about being late last time and you're on time.
Early.
Yeah, you're early. And
I
thanks
made
for,
sure.
thank you. And Drace, thank you for dressing appropriately for court.
Phone number on the bottom, I'll get you. Oh, you're lucky. Okay, another. Phone number, just, yeah, the some on the bottom.
Okay, I just noticed we have the old docket sheet back.
Yeah.
Okay. Jose Gonzalez.
Morning, Your Honor. He's on Zoom. We're waiting for the CPS records and apparently the date's been told it won't happen until July 29th.
All right, state. Family violence. All right, Jose Gonzalez, are you there?
He says he
Important legal moment here because it's a felony. Jessica is prohibited from owning weapons or ammunition. These aren't just formalities. Any violation could land her back in jail immediately. Notice how strict and precise these conditions are. This is a reminder the law is always watching.
All right, so here's my question. I don't know anything about your case. This manslaughter case, is it involving a vehicle?
it is.
Okay,
Both parties were in a vehicle.
all right. So this is, I guess, alleged to, well, the state is alleging it's manslaughter. I'm assuming there's
We,
accident or
it
something.
is, and the
Okay.
point of contention is going to be causation. So that's going to be a heavily litigated issue.
All right, we're going to go on the record. Court is calling 2023 CR 8868, State of Texas versus Samuel Brock. Could I have parties announced for the record for the state?
Andrew Harrison.
Defense?
Jody Sawyers.
And are you Mr. Brock?
ma'am.
All right, defense has filed a motion for continuance. State, do you have any objections? All right, so this case has been going on in this court since January 2024. And I'm just receiving information that there may be medical records for the complainant. Why am I just now receiving this?
That's a great question. The state asked for 3 continuances while they said they were talking to the complaining witness, and we thought we were going to work this case out.
And when they talked to the complaining witness, they still had to talk to their superiors. So the state got 3
Right,
continuances.
complaining witnesses, it's a manslaughter that they,
Their family, his family.
the family,
I
okay.
apologize. To be clear, his family. So, I mean, we thought we were going to resolve this case. And that's what we were led to believe at the last setting that we had. We were not able to resolve it. And that is what shifted gears. So we are not, I mean, we have the records, but we don't have the records that are behind the autopsy reports that we now need, because as I put in there, the drug screen initially says no drugs detected, but now I need the underlying data because I have something that actually contradicts the fact that this particular complaining witness would have and should have had stuff in his system.
so you're assuming that because he was prescribed these medications, he was taking these medications?
Well, he said the day before to his doctor he was taking them. So that, and coupled with the fact that I need to see what they screened for, it's possible that they didn't test, that these wouldn't have triggered. And I need to know that. So that's where we're looking for that data as well from the state, as well as we need time to get experts, which we believe it will take us approximately 30 to 60 days. I'm asking for a reset toward the end of August.
Okay, I can tell you right now, we're not doing 30 to 60 days for a jury trial. You all are coming back because this is an old case. We've been dealing with discovery since January, and I know people don't think that's old, but in this court, that's old. So this is what's going to end up happening. We're coming back, and we're coming back on July 15th. On July 15th, state whatever records you have from the autopsy report, whatever medical data as it relates to drug testing needs to be turned over at that time or before that time to the defense. And defense, you need to specifically address with the state what you're looking for with regards to those records. And then you all need to be off record and talk to the inmate and see where the toxicology report is. Does everyone understand?
Yes.
The records that you've received, they're going to have been reviewed by the 15th. Okay?
Now, Your Honor, just to let the court know, I have had a vacation letter on file for the 15th through the 22nd for months now. It's my 50th birthday.
Oh, no, you got to celebrate your birthday. So we're going to come back on July 10th.
Yes. Thank you, Your Honor.
All right. Oh, and happy 50th.
Thank you.
They say that's the best one.
I keep saying it only comes around once, and I was like, so did my 49. I don't understand why we're.
And you know, when you tell people you're 29, that's the one that they don't believe. Because when I was 29, they're like, you're not 29. Either, nobody is ever 29. They act as though that age does not exist. But when I was 50, those were the days. All right, once you sign the reset form, you're excused.
Okay, thank you, Your Honor.
You're welcome.
Have a good day, Your Honor.
Thank you, and thank you for dressing appropriately for court.
Fast forward jury trial dates, records and resets. This is the procedural grind of the courtroom. The judge is balancing fairness with urgency. 30-60 day delays. Everyone must return promptly. For viewers, it's a behind the scenes look at how legal strategy isn't just arguments, it's timing, records and logistics.